फ्लैग लगाए थे वो कहाँ है? वो पेपर बुक बदल बदल के थोड़ा ना चलेगा। वेयर इज माई पेपर बुक? दोबारा इतनी मेहनत थोड़ा ना करूंगा मैं। वो पेपर बुक कहाँ है जिसमें मैंने फ्लैग लगाया था? कहाँ गई वो पेपर बुक? वो आधे दिन छुट्टी चले गए। ऐसे बदल कैसे जाती है पेपर बुक? पेपर पेपर बुक बदल कैसे जाती
वो
है?
पेपर बुक हमारे पास थी लास्ट टाइम पे।
कौन सी वाली?
ये वाली।
मेरे जिस पेपर बुक में फ्लैग लगाए थे,
हाँ,
आर्गुमेंट सुने थे, वो कहाँ चली गई? किन्होंने रखा है? तो फिर कैसे होगा, बहस कैसे होगी? चलिए चलिए देखूंगा मैं। चलिए आप ऐसा कह रहे हैं, देखूंगा। चलिए शुरू करिए प्लीज।
These are all checks.
ये माइक चालू।
The prosecution cases that the deceased was done to death on 29/4/21.
जी, हम अगर रिकैप करें इन शॉर्ट, प्रोसिक्यूशन केस इज दैट 29/4 को उनकी डेथ हुई है इलेक्ट्रोक्यूशन से। आपके जो पक्षकार है वो 30 तारीख को झांसी गई हैं। उनकी डिफेंस ये है 30 तारीख को वो झांसी गई थी कोविड के ट्रीटमेंट के लिए। उन्होंने डॉक्टर के डिफेंस में बयान कराया है। इनके जो बेटा है उसको भी दिखाया था उन्होंने। देन शी केम बैक ऑन 28th 29th 30th नाइट बैक टू छतरपुर। ठीक है, ड्राइवर के बयान कराए जिसने कहा कि ये लेकर गए थे। ड्राइवर ने कहा DW4 है, इफ माय मेमोरी सर्व्स मी राइट।
ड्राइवर PW12।
PW है DW है?
PW।
जो ड्राइवर
PW,
PW
PW12.
डॉक्टर ड्राइवर ने कहा कि ये रिपोर्ट लेने के लिए नहीं गई, घूमते रहे डॉक्टर, उसके बाद में वापस आ गए। उसने कहा मुझे जाना है, वापस आ गए। इनका डिफेंस ये है कि पोस्टमार्टम रिपोर्ट में जो ड्यूरेशन दी हुई है दैट ड्यूरेशन डज नॉट कोऑपरेट विद 29th। फर्स्ट थिंग। सेकंड थिंग, शी वाज इन लव विद हर हस्बैंड। उन्होंने कुछ फोटोग्राफ्स वगैरह के ऊपर रिलाई किया था, कुछ एक आध दो पत्र भी दिखाए थे। एंड बेसिक इनका सबमिशन था कि अगर इलेक्ट्रोक्यूशन से मारते तो उनकी चमड़ी के ऊपर उस कॉपर या एल्युमिनियम वायर के मेटेलिक टेस्ट होना चाहिए था। दिस इज व्हाट शी सबमिटेड। यही कहा था ना मैडम आपने? उसके बाद इनका यह भी कहना था कि इनके घर में जो सेफ्टी इक्विपमेंट लगे हुए थे उन सेफ्टी इक्विपमेंट के रहते हुए इलेक्ट्रोक्यूशन नहीं किया जा सकता था, ट्रिप हो जाता कनेक्शन इमीडिएटली। उसके एंड मेन थ्रस्ट वाज अपार्ट फ्रॉम दीज आर्ग्यूमेंट्स, मेन थ्रस्ट वाज बिकॉज आई हैव कंप्लीट नोट्स, तो इसलिए
Yes, ma'am.
जितना वॉट एवर आई एम एबल टू रिकॉल आई एम शेयरिंग विद यू।
Absolutely correct.
और मेन थ्रस्ट इज कि बॉडी का जो रिगर मॉर्टिस है और जो कंडीशन है वह कंडीशन 29/4 से लेकर जब 1 तारीख को पोस्टमार्टम हुआ है उसके बीच की स्थिति नहीं दर्शाती है, लुकिंग टू द फैक्ट दैट इट वाज मंथ ऑफ समर एंड सेकेंडली कूलर हैज बीन शोन इन द रूम। तो उन्होंने यह भी एक डॉक्टर बड़कुर की किसकी एविडेंस कराई है डिफेंस में, ये कहने के लिए कि वो कूलर चलता है तो और जल्दी जो है पेट्रिफिकेशन होता है बॉडी का, प्यूट्रिफिकेशन होता है, सॉरी। इज इट राइट?
Absolutely.
हाँ, अब आगे आपको जो बताना है वो बताइए।
Then I shall just carry this argument forward so far as duration of death is concerned.
जी,
Because
ये दीजिएगा, इनके आर्गुमेंट्स भी तो थे। हाँ, जी
Milad, I submit
जी
that if death has not taken place on the night of 29/4/21,
हाँ
then the entire prosecution case has to fall to the ground.
जी
Cannot be changed now.
जी
Now, when prosecution says, it's come to this opinion,
जी वो तो आपने क्रॉस एग्जामिन किया होगा ना डॉक्टर वो पोस्टमार्टम का पीडब्ल्यू
that he's PW1,
पीडब्ल्यू 1
he gives absolutely no data.
जी क्या पूछा आपने क्रॉस एग्जामिनेशन में
His examination in chief itself does not reveal any data. On what basis he says
जी
that death was 36 hours earlier.
जी
Now, if he does not place before this honorable court data
जी
on the basis of which opinion has been given,
जी
that his entire evidence has got to be ignored, and then we shall have to go back to the textbooks. And for this proposition of law,
जी
let I rely on AIR 2010 Supreme Court 806,
यस
paragraphs 14 and 17.
जी
That I've given printouts.
हाँ जी यस
Let kindly come.
पढ़िएगा पैराग्राफ 14
14. It is not the province of the expert to act as judge or jury. It is stated in Pickley versus Jones that the real function of the expert is to put before the court all the materials, together with reasons which induce him to come to the conclusion, so that the court, although not an expert, may form its own judgment by its own observation of those materials.
जी
Furthermore, an expert is not a witness of fact, and evidence really is of an advisory character. The duty of an expert witness is to furnish the judge with the necessary scientific criteria
जी
for testing the accuracy of the conclusions,
जी
so as to enable the judge to form his independent judgment by application of these criteria
जी
to the facts written by the evidence in the case.
जी
The scientific opinion, evidence, if intelligible, convincing, and tested, becomes a factor and often an important factor
जी
for consideration along with
Ji.
other evidence of the case. Now, Millet, please come to para 17.
जी
In the article Relevance of Expert's Opinion,
जी
it has been opined that the value of expert opinion rests on the facts on which it is based and his competency for forming a reliable opinion.
जी
The evidentiary value of the opinion of an expert depends on the facts upon which it is based and also the validity of the process by which the conclusion is reached.
जी
Thus, the idea that is proposed in its crux means that the importance of an opinion is decided on the basis of credibility of the expert
जी
and the relevant facts supporting the opinion,
जी
so that its accuracy can be cross-checked. Therefore, the emphasis has been on the data on the basis of which the opinion is formed. The same is clear from the following inference. Mere assertion without mentioning the data or basis is not evidence,
जी
even if it comes from an expert.
जी
Where the experts give no real data in support of the opinion, the evidence, even though admissible, may be excluded from consideration as affording no assistance in arriving at the correct value.
जी
Ramilat has not told us why. He says that death has taken place 36 hours earlier. On the other hand, Millet, I've brought the opinions of 3 experts in their textbooks, each of which says that the process of decomposition will start round about 18 hours after death. And decomposition starts, Millet, with the changes of the skin, color of the skin, and the presence of foul-smelling gases. None of these symptoms are present on the body at the time of postmortem examination.
Right.
If that is so, in this compilation, there is Lyon's Medical Jurisprudence.
Ji.
That is a book not normally available.
Ji.
And what they say is, at page 149,
Yes.
color changes.
Ji.
In about 24 hours, often earlier, a green patch appears on the abdominal wall in the right iliac region. This enlarges rapidly within a few hours. The whole abdominal wall and the intercostal spaces are affected. The coloration now spreads to the face and considerably to the limbs.
Ji.
At the same time, decomposition of the blood causes staining of the walls of the vessels, and the more superficial of these now show through the skin as dark brown streaks, thus producing a marbled appearance on the surface. This marbling is not very evident on dark complexions until, at a later stage of decomposition, the epidermis has peeled off. A putrefactive odor is noticed at about the same time as discoloration becomes evident. So, here there's no discoloration of the skin.
Ji.
Neither is there any smell from the body. And consequently, death has not taken place later than 18 hours. And if that is so, Millet, then the doctor has died sometime between the night intervening the 30th and the 1st. Now, Millet, how he has died, one does not know. Maybe electrocution. But if he is not dead on the 29th, if he is not dead on the 30th, my conduct in going to Jhansi now cannot be used against him.
Okay.
Some minutes, please also have a look.
But presuming that, taking both these situations into consideration, one, assuming that he died on 29th, you were in house on 29th. Presuming he died on the intervening night of 30th and 1st, you again came back to Chhatarpur on 30th night as said by your PW12, corroborated by PW12, and this is also your admission.
Also, my statement
Yes,
as DW1
What DW1?
that he is alive when I've come back.
When you came back, he was alive.
There are two people who live in that house.
She and her son.
So who has committed the murder? Assuming it's a case of murder.
Right.
It's committed. Well, the presumption would not be.
Any presumption से तो नहीं होगा ये. We understand this.
So then, how do we say that it's this appellant who has committed the murder?
जी.
Of course, Milad, if he's died on the 29th, then it's a different matter.
जी.
Then, of course, my conduct would speak against me.
Yes.
But I submit that there's not an iota of evidence to hold that the doctor died
जी.
earlier than the night intervening the 30th and the 1st.
जी.
And if that is so, Milad, and since two people are living in that house,
जी.
I submit that I cannot be made liable for this alleged murder.
आप इस थ्योरी को लेकर आए हैं क्या कि since there were two persons living in the same house, unless नहीं ये आज जो आप आर्ग्यूमेंट कर रहे हैं वो सजेशन कहाँ है आईओ को?
I don't have to give any suggestion, brother. The fact is that two people are living in that house.
Okay.
How? What suggestion can I give to the IO?
Sorry, please, जी,
Then I would have absolutely no idea
जी,
as to who has committed the murder.
जी,
So, the on the subject
जी,
has been made up
जी,
in 1996 7 SCC
जी,
308. That is not in that compilation.
okay,
Ask them to take the book out for your chips.
Book now vehicle.
1996 7 SCC 308,
जी,
paragraphs 22 and 23.
जी, पैराग्राफ
22 and 23.
जी,
That here a girl was murdered inside the house, a married woman. That takes us to the last circumstance on which strong reliance was placed by the High Court for convicting the appellants. That pertains to the scene of offence. It is true that the scene of offence was shown to be the kitchen in the household of the accused, where all the four accused were staying. It is also true that at the time when the dead body of the deceased was found lying in the kitchen, witnesses Santosh Kumari, PW14, found that the kitchen was in perfect order and there was no smoke in the kitchen. The kitchen was neat and clean and there was no smell emanating from the kitchen. But even if that is so, it is difficult to appreciate how the circumstance by itself points a guilty finger to the accused or any one of them, merely because deceased Krishna Kumari, who was staying with the accused, had died a homicidal death in the household, and her dead body was found in the kitchen with post-mortem burns. It cannot be said that the said circumstance by itself would connect all the accused or any one of them with the crime.
जी, 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 जी,
And so far as motive is concerned, please have a look at the evidence of that cook who has stated against me.
जी,
She is Vinod Maya Gupta, PW5.
जी,
And she says, third line, paragraph 1.
just a minute.
Yes.
जी,
थर्ड लाइन मिनट्स
जी,
घटना करीब के करीब 1 साल पहले डॉक्टर साहब के घर पर खाना बनाना बंद कर दिया था. Consequently, Millet, she has no fresh knowledge.
हाँ ठीक है, that is true.
Yes. Then she says, जब मैं खाना बनाने आती थी तो डॉक्टर साहब और उनकी पत्नी के बीच बहसबाजी सुनी है और उनका झगड़ा चलता रहता था. मैडम कभी कभी पूछती थी कि डॉक्टर साहब कैसे हैं, तो मैं डॉक्टर साहब को बता देती थी कि मैडम पूछ रही हैं. तो डॉक्टर साहब ने कहा कि तो मैडम को फोन नहीं उठाया करो.
जी,
डॉक्टर साहब अच्छे स्वभाव के थे और मैडम शंकुला स्वभाव की थी,
शंकालू,
चंकालू स्वभाव की थी. मैडम डॉक्टर साहब का वो शक करती थी कि तुम गलत हो, किसी को रखे हो.
जी
Please come to the cross examination.
जी
And he said, Miller,
जी
for last 8 or 9 lines,
जी
ये कहना गलत है कि मैंने जो बातें बताई हैं वो सब सुनी सुनाई बताई. स्वतः कहा कि जो देखा है वो बताया है.
जी
मैंने पुलिस को बयान देते समय बता दिया था कि मैडम और डॉक्टर साहब में झगड़ा चलता रहता था और मैडम फोन करती थी और डॉक्टर साहब का पूछता थी, तो डॉक्टर साहब ने कहा था कि मैडम का फोन मत उठाना.
जी
यदि मेरे पुलिस बयान दी एक में उन बातें ना लिखी हो तो कोई कारण नहीं बता सकते.
जी
मैंने पुलिस को बयान देते समय ये बता दिया था कि मैडम शंकालू थी और डॉक्टर साहब पर शक करती थी. यदि पुलिस बयान D1 में ना लिखा हो तो कारण नहीं बता सकता.
जी
So, vital omissions in the case study statement.
जी
How will we now believe her evidence?
Exhibit D1 is page number
That I don't have that.
105. जी ठीक है. हाँ तो पढ़ेंगे ना बात ये पढ़ा जाए. जी
10 minutes we have the Caesar. Before that, we have the evidence
जी
of a relative of the deceased,
जी
Chandilal Bajpai,
जी
PW4.
जी
And there's also a pen drive on the basis of which he says that he had made certain
वो
recordings.
मैडम ने बताया था 65B का सर्टिफिकेट नहीं लगा है.
Yeah,
वो देख लियो, हमने रिकॉर्ड कर लिया सब.
very well. So then that goes. Next of it, minute he says,
यही आर्ग्यूमेंट किया था ना मैडम ने, 65B का सर्टिफिकेट नहीं है. जी
so I don't have to touch that. Case law, would your lordship like on that?
हाँ डेफिनेटली.
Yes. Millet, case law is
एक एक कंपाइलेशन में से बताते जाइए एक एक करके.
ये
जी
yes, ये compilation में नहीं है सर. All SCCs I have not brought over there. This is 2027 SCC, page 1.
जी अरुण पंडित राव
कोटेकर. Minute, your lordship's minute.
हाँ ठीक है ठीक है. एब्सेंस ऑफ 65B सर्टिफिकेट.
Yes.
ठीक है बताया था आपने. शी हैज ऑलमोस्ट कवर्ड एवरीथिंग.
True. I'm just carrying it
जी
forward.
जी जी जी
Nothing more.
यस.
Well, then we come to the seed, the discovery statement
जी
made by her.
जी
Well, at the time when that discovery statement was made, she was not an accused.
यस दैट इज ट्रू.
And
इन्होंने कहा कि जब इनका 27 का मेमोरेंडम लिया गया तब वो एक्यूज भी नहीं थी और अरेस्ट भी नहीं, कस्टडी में भी नहीं थी.
yes,
इसलिए वो मेमोरेंडम जो है एडमिसिबल नहीं. 2 रूलिंग भी दिया उसके ऊपर.
good. That's, well, I've got one
मतलब
PIR 2023 Supreme Court.
आपने दे दिया था ये 2023 दे चुके हैं.
Very, so then that.
उसको रिपीट मत करिए, दे चुके, पूरा कंपाइलेशन दे चुके हैं ये.
Well, apart from that, what I'm submitting is this, that this evidence has been planted on this lady.
ओके.
Now, I say this
Hmm.
because, Millet, police had already come to the house on the first.
हाँ एट हर इंस्टेंस.
Inquest proceedings had taken place.
जी
It's a small house.
हम्म
A map of that house was then drawn on the 6th.
जी
So police were coming and going.
जी
The police would also know
जी
that shock had been administered
जी
and they would be on the lookout for some article as to how the doctor could have been electrocuted in the house.
जी
And despite that minute, till the 8th, these articles are not found.
जी
So it's a house in joint possession.
yes
It's not her statement that has led to discovery of any article. Her son is staying with her, a grown son. So how do we say that she was in exclusive possession of these articles?
जी
But so far as PW4 is concerned,
जी
apart from the fact that there is no certificate under 65B,
जी
the easiest thing in the world would have been for the police to have taken out the call detail records.
जी
Well, in every case that your lordships must be seeing now, all detailed records are there.
so what do you want to prove through call details?
Well, that there was a telephonic conversation between PW4 and the deceased.
Okay. And once you say that 65B certificate was not there,
Yes.
then that goes. That cannot be a substantial ground to uphold your conviction.
Very well, Millet.
So उसके बाद तो next argument की जरूरत ही नहीं है.
ठीक है.
PW4 की बात करें, छेदीलाल वाजपेयी जी की, कि उन्होंने कहा कि उसने आगे कहा था कि फोटो देखा था कि बचाओ मेरे को, दो कमरे में बाथरूम बन सकती थी. Not factory ready visible हो जाएगा.